The nation was riveted, glued to their screens and radios, as a legal drama unlike any other began to unfold in Jakarta. The air was thick with anticipation, and the story quickly became the talk of every office, cafe, and street corner. At the center of this storm stood Hotman Paris Hutapea, Indonesia's most flamboyant and controversial lawyer, known for his sharp suits, gold rings, and even sharper tongue. With cameras flashing and reporters jostling for position, Hotman made a bold public plea that would soon dominate headlines. He stood before a wall of microphones, his presence commanding the attention of the nation, demanding nothing less than a special hearing at the presidential palace. His mission: to defend his high-profile client, Nadiem Makarim, the former Minister of Education, who now found himself at the center of a corruption scandal that threatened to shake the very foundations of government. Hotman didn't just ask for a hearing, he issued a challenge. He claimed, with his trademark bravado, that he could prove Nadiem's innocence in just 10 minutes. All he needed, he insisted, was an audience with President Prabowo himself. The lawyer's confidence was palpable, and his words echoed across social media and newsrooms alike. This was no ordinary legal maneuver. It was a calculated spectacle, a high-stakes gamble that blurred the lines between law, politics, and public relations. Hotman invoked his past ties to Prabowo, reminding everyone of their shared history, and in doing so, he openly challenged the norms of Indonesia's justice system. The request sent shockwaves through the political and legal landscape. Analysts debated the implications on live television, while legal experts questioned whether such a direct appeal to the president was even constitutional. The move raised urgent questions about executive interference, the independence of the judiciary, and the delicate balance of power in Indonesia's democracy. Suddenly, the story was no longer just about Nadiem's alleged corruption. It became a national spectacle, centered on Hotman's audacious gambit and the palace's next move. The public watched, fascinated, as the boundaries between legal defense and political theater blurred before their eyes. The case was instantly elevated from a routine investigation to a national drama, with every twist and turn dissected by pundits and ordinary citizens alike. The stakes had never felt higher, and the outcome seemed poised to set a precedent for years to come. All eyes turned to the Istana Negara, the presidential palace, as the nation waited with bated breath for a response that could redefine the boundaries of law, politics, and power in Indonesia. On September 4, 2025, Indonesia was stunned. Nadiem Makarim, Gojek founder and former education minister, was officially named a corruption suspect. The Attorney General's office accused him of abusing his authority in the procurement of Chromebooks for schools, a flagship project of his digital education push. The charges carried the threat of life imprisonment. Nadiem was swiftly detained, his confident public persona replaced by the image of a man in a detainee's vest. He maintained his innocence, telling reporters, "God will protect me, the truth will be revealed." The fall of such a celebrated technocrat sent shockwaves through both the political and tech worlds. Nadiem's arrest was the climax of a meticulous, months-long investigation. It began with a travel ban in June 2025, signaling he was a central figure in the Chromebook probe. He endured 3 marathon interrogations, 12 hours in June, 9 in July, and a final session in September. Each session brought him closer to formal charges, as investigators methodically built their case. The process was deliberate, not rushed, with every step tightening the legal net. On September 4, after hours of questioning, Nadiem was named a suspect and taken into custody. For Nadiem, it was a slow, inevitable march toward a life-altering moment. Nadiem wasn't alone in the dock. The Attorney General's office named 5 suspects: Nadiem, 2 former ministry directors, Sri Wahyuningsi and Mulyatsya, a special staffer, Juris Tan, and an external consultant, Ibrahim Arif. The case revealed a network of bureaucrats, advisors, and outside experts allegedly colluding to rig a massive government contract. Both directors were detained. Juris Tan fled abroad and became a fugitive on Interpol's red notice. Ibrahim Arif, the consultant, was placed under city arrest due to health reasons. prosecutors allege this group coordinated to manipulate procurement specifications, locking out competition. The investigation aims to unravel who benefited and how the scheme was executed. Together, these five form the core of a multi-layered conspiracy case. At the heart of this unfolding case lies a staggering financial loss for the state. Nearly 2 trillion rupiah, which translates to about $120 million. This massive sum is directly linked to the government's procurement of Chromebooks for schools, a project that was initially intended to modernize classrooms and bridge the digital divide. However, what was meant to be a leap forward in education has now become the center of a major corruption scandal, raising questions about transparency and accountability in public spending. Prosecutors allege that Nadiem Makarim, the Minister of Education, abused his position of authority by steering the lucrative contract toward Google's Chrome OS. This decision, they claim, was made after a series of secretive, closed-door meetings between ministry officials and representatives from Google, away from public scrutiny. In 2021, a ministerial regulation was issued that, according to investigators, set the technical specifications for the devices so narrowly that only Chromebooks could possibly qualify. This move effectively excluded all other competitors from the bidding process, raising red flags about fair competition and due process. This so-called locking of specifications is now the crux of the abuse of power charge. By tailoring the requirements to fit a single product, prosecutors argue that the minister undermined the principles of open procurement and fair market access. The prosecution contends that this wasn't a matter of simply choosing the best technology for students, but rather a deliberate attempt to create a monopoly, violating established procurement rules and sidelining other potential suppliers. Investigators are now meticulously examining the timeline of Nadiem's meetings with Google, as well as the internal communications and decision-making process that led up to the controversial decree. Every detail is under scrutiny, from meeting records to procurement schedules. While Google has publicly denied any direct involvement in the sales process, the investigation's focus remains on whether Nadiem's directive predetermined the outcome, ultimately causing massive losses to the state and sparking a national debate about corruption in public procurement. Hotman Paris's defense is simple and relentless. 3 pillars. First, Nadiem never received a single cent from the Chromebook deal, no personal enrichment. Second, there was no price inflation. Laptops were bought at fair market value through the government's e-catalog system. Third, no one else unlawfully benefited. The process was transparent and above board. Hotman argues that without personal gain, price gouging, or unlawful enrichment, the core elements of corruption are missing. He frames Nadiem as a reformer, not a criminal, and claims he could prove this to the president in 10 minutes. The defense bets that this clear, 3-point narrative will outshine the prosecution's complex allegations. The palace's response to Hotman's plea was swift and unequivocal. No special hearings, no interference. Presidential spokesperson Hassan Nazbi reaffirmed the government's commitment to the separation of powers and respect for legal process. The case, he said, belongs to the Attorney General's office and the courts. No exceptions, no political favors. The rejection was a clear signal. Justice would not be dispensed in the halls of power, but in the courtroom. Intervening would have set a dangerous precedent and undermined the rule of law. The onus now returned to Nadiem's legal team to fight in court. The palace's firm no reinforced the integrity of Indonesia's justice system. The Attorney General's office echoed the palace's stance, vowing to let the law take its course. Spokesperson Anang Supriyatna emphasized professionalism, due process, and the presumption of innocence. Nadiem, like any suspect, would have his rights protected, and the prosecution would bear the burden of proof. The investigation would remain thorough and impartial, following evidence wherever it led, even beyond the 5 named suspects. The office refused to be drawn into public spectacle, focusing instead on its mandate. The message: no shortcuts, no show trials, just a methodical pursuit of the truth. The public was assured that justice would be served by the evidence, not by media drama. The Nadiem Makarim case has become more than just a headline. It is now a defining moment for Indonesia's justice system, a test that will be remembered for years to come. With a high-profile public figure at its center, the fundamental principles of due process and the presumption of innocence are under intense scrutiny, not just by legal experts, but by the entire nation. In moments like these, it is crucial to remember that allegations, no matter how serious or sensational, are not the same as convictions. Justice must be rooted in facts and evidence, not in rumors, speculation, or the shifting tides of public opinion. Nadiem's defense team has the right to challenge every claim, to question every piece of evidence, and to ensure that the prosecution meets the highest standard, proving guilt beyond a reasonable doubt. This is the cornerstone of a fair legal system. No one, regardless of their status, influence, or popularity, is above scrutiny or exempt from the law's reach. The process must be conducted with fairness, transparency, and impartiality at every stage. Justice must be blind to power, reputation, and public pressure, ensuring that every individual receives equal treatment under the law. The outcome of this case, whatever it may be, will have a profound impact on public trust in the rule of law. It will set a precedent for how future cases are handled and how justice is perceived in Indonesia. The world is watching closely, and the verdict will echo far beyond the walls of the courtroom, shaping Indonesia's reputation for justice on the global stage.